This is our sixth and final day in the trial type evidentiary hearing in case number 9461. We're prepared to move to closing arguments of parties that did not have an opportunity to make arguments yesterday, but before we begin, are there any preliminary matters?
None, Your Honor.
Okay. Thank you. Ms. McLemore, you have the floor.
Good morning, Commissioners. This is only the second time that PPRP and reviewing state agencies have recommended a denial of a CPCN application for a transmission line project to this Commission. This recommendation is not made lightly and is only after serious and significant deliberation by the reviewing state agencies. This case requires state leaders to balance the asserted need and benefits of an infrastructure project that will benefit the region against the costs and impacts that it will impose on the state's residences and resources. Specifically in this case, this Commission must balance the development of the region's transmission system to meet the needs of a grid of the future against the importance of preserving Maryland's heritage, natural beauty, and real investment by both residences and government into sustaining its agricultural economy. The project is the poster child of what can happen if a project is not appropriately cited under Maryland's siting statutes. If statute siting requirements are not incorporated early in the development of a greenfield project, avoidable consequences are inevitable. Now, Project 9A is unique in that it is a first for PJM and for the transmission developers in this region. As testified by Transource witnesses Weber and Hurling, 9A was chosen in PJM's first ever competitive process to choose a market efficiency project, and such processes can change. The proposed project, along with other portions of 9A, will address congestion in a portion of our region and reduce the electricity prices of some of the region's electricity customers. Addressing market efficiency is a part of PJM's responsibilities under FERC Order 1000. And the process to competitively evaluate and choose solutions by PJM has been approved by FERC. However, Order 1000 also specifies that in this process, state siting requirements must be incorporated. And assuring compliance with Maryland siting requirements is the responsibility of this Commission. As noted by PPRP witness Kelly, PPRP and reviewing state agencies recommendation to deny the project was only made after considerable investigation showed that there was existing transmission lines near the eastern portion of the IEC project located partially in Harford County, Maryland. Because these existing lines were not considered in developing and siting the project, it became clear that constructing the project in its proposed route on the east side would cause avoidable and significant impacts to Maryland's socioeconomic and environmental resources. Most notably, the state's agricultural resources in Harford County and the state's investment, as well as the citizens of Harford County, would be harmed unnecessarily. As explained by Maryland's Secretary of Agriculture, Secretary Bartenfelder, the agricultural industry is the leading industry in the state's economy. Given the importance of agriculture to Maryland, the finite property in the state upon which it depends, and the small margins that accompany family-owned farming today, the impacts of a new transmission line over agricultural property where those lines previously did not exist is significant and must not be taken lightly. After some analysis by PPRP, it became clear that adding an additional circuit to the existing Conestone to Otter Creek transmission line and replacing the lattice towers in Maryland's portion of the Grayston to Manor line with monopole structures would have been a favorable alternative that should have been considered as part of the development of the proposed IEC project. But it was not examined in siting the IEC East, and subsequently, the impacts that would be avoided by using existing rights-of-way were never identified or compared with the proposed greenfield prior to the submission of the application in this case. Now, after the persistence of PPRP in reviewing state agencies and other parties in the case, using these existing lines is now irrefutably a viable option. According to PJM, one electric configuration using these lines passes its benefit to cost analysis and would meet PJM's identified needs. Maryland siting requirements for an electric transmission line are largely centered around two statutory provisions. Section 207 of the Public Utility Article, which provides for factors to be weighed in a CPCN review, including the impacts to the state's socioeconomic and environmental resources. The second provision is Section 209, which requires that existing transmission lines be examined when siting a greenfield transmission line project in Maryland. Important to note, and particularly relevant in this case, under this statute, the existing transmission lines should be examined regardless of whether the developer of the project owns them. As admitted by Transource and PJM witnesses, however, the existing transmission lines were not analyzed as an alternative to the IEC East project prior to submission of the application. Specifically, at the point of carrying out the siting studies, existing lines were not considered. Transource witness Baker, who conducted the siting studies for the project, stated that he was hired to develop the siting study specifically for 9A, a greenfield line already chosen by PJM. He did not discuss the siting of the project with PJM as part of any constructability analysis, and using existing lines was not presented to him as an alternative. During the PJM's RTAP process, these existing lines were also not considered. Transource witness Hurling explained that PJM does not weigh societal costs in its consideration of projects for award. Also, while PJM carries out a constructability review to inform PJM's comparison of proposed projects submitted in its window, its RTAP window, this PJM review is somewhat high level. In the case of the IEC East, PJM only considered and chose a project that simply included a greenfield line that would go from point A to point B. At the end of the day, PJM views the siting of the project and the project's compliance with state siting requirements as within the transmission developer's purview. However, Transource also did not consider the existing lines as an alternative or the requirements of Section 209 when developing its proposal to submit into the PJM's 2014-2015 window. Mr. Ali asserts that he considered the existing lines as an electrical alternative when developing proposals to submit to PJM. Even if Mr. Ali did consider these existing lines, which seems a bit contrary to discovery, which has been admitted in the record in this case, such a consideration was very limited and was simply discarded when the greenfield route resulted in a higher benefit-to-cost ratio and thus more likely to be chosen by PJM. In short, any consideration by Transource was simply dismissed as an inferior electrical alternative to the proposed route. Finally, during Transource's interactions with state agencies prior to filing its application, analysis of an alternative siting using these existing transmission lines in Harford County was not presented to MALF in discussions about the state's agricultural easements, nor was it addressed in the pre-application meetings with PPRP. Only after extensive evaluation, and particularly by PPRP witness Etheridge, were these existing lines identified as an alternative to the proposed project, albeit a conceptual alternative. It is important to point out that PPRP was not proposing the conceptual alternative as a project. That is not PPRP's role. Instead, PPR was simply attempting to provide this commission with the information it needed for its examination under PUA Section 209. However, now it is unrefuted that conceptual alternative 3A using these lines is a viable option. Transource continues to stress that the electric configuration of the IC East project is superior electrical configuration and would provide greater congestion relief at a lesser cost. However, IC East was developed, chosen, and sited without consideration of Maryland siting requirements or the societal cost it imposed on Marylanders. And this mistake will have significant detrimental impacts to Harford County and the state's preserved agricultural resources if constructed. Such impacts would include economic harm to those farmers who own property where the IEC East project will traverse, as currently cited, and the state's significant investment to preserve the state's farmlands. While the need for this project is based on a regional need, the siting that this commission is considering is in Maryland, where, along with Pennsylvania, the lines will traverse. And the decision before this commission is whether there is a need for this project at this time, and if so, whether the benefits to the region, which includes Maryland, outweighs the significant societal cost borne solely by Maryland and its neighbors in Pennsylvania. In the context of the region's electric transmission infrastructure, we agree with Dr. Tierney's point that PJM process and the state siting process can coexist. However, this does not mean that a project should be given a CPCN when state siting requirements have been ignored in its development and the project unnecessarily imposes negative impacts on state resources. If the Commission determines, in response to Commissioner O'Donnell's concerns posed yesterday regarding process, I would point out that if the Commission determines that there is a need for the project at this time, but that, given the significant impacts which could be avoided by using existing lines, it was only in the public's interest to construct the project by using existing transmission lines for the IEC East portion, and granted a CPCN on that condition, and if Transource then accepted such a conditional CPCN, PPRP would work with Transource, the parties, and other necessary parties to develop recommended conditions for the IEC West and for the 3A route for the IEC East portion in a timely manner after it's been given the necessary information. It is not PPRP's or reviewing state agencies' position that market efficiency projects are not needed, and likely would not necessarily oppose such projects if they are properly cited. However, as admitted by Mr. Hurling, market efficiency projects to avoid congestion do not have the same level of urgency about them as does a reliability project to avoid a NERC violation. As for this project, there is sufficient time to appropriately cite an eastern route and still address the congestion and reliability that IEC project is aimed at addressing. PJM has indicated that it will work to incorporate states' needs to address siting concerns into a project as long as the project would still meet PJM's needs. As stated by Transource witnesses Hurling and Ali, conceptual alternative 3A would meet PJM's needs. However, as regarding a CPCN for the project as currently proposed, and for the reasons specified in the secretarial letter submitted in this case, PPRP and the reviewing state agencies must still recommend denial of this project. Thank you.
Thank you, Ms. McElmore. Counsel for Office of the People's Counsel.
I'm going to that podium. Leave this here. Madam Reporter, can you hear me or not?
Can you possibly pull that mic a little closer? I think it's on.
Maybe this will be better. Is this better? Okay. Mr. Chairman, Commissioners, thank you for paying such keen attention to the testimonies of the numerous witnesses in this case. I also compliment all counsel in this case for ensuring that all of the issues in the case have been thoroughly analyzed and discussed. It bears repeating that Transource shoulders the initial burden of production as well as the ultimate burden of persuasion, both of which comprise the burden of proof. While the burden of production may shift during the course of a trial, the burden of persuasion never shifts from one party to another and thus remains with Transource throughout. As well, Transource must prove its case by a preponderance of the evidence. Thus, if the Commission finds the evidence supporting each party of equal weight, the Commission must rule against Transource. In this case, Section 7-209 of the Maryland Public Utilities article plays a particularly large role. Pursuant to this statute, the Commission must examine alternatives to the construction of a new transmission line in a service area, including the use of an existing transmission line right-of-way of another company, if the use of the transmission line will best promote economic and efficient service to the public. Therefore, there are two issues raised in the case by the provisions of 7-209. The first is the Commission's examination of alternatives to Transource on existing rights-of-way. As far as I could tell, the only evidence of an acceptable alternative to the proposed transmission line, which makes use of existing rights-of-way, was offered by PPRP's expert, Mr. Etheridge. Again, as far as I can tell, there are no other alternatives in the record for the Commission to consider. The second is that the promotion of economic efficiencies is not just to ratepayers, but to the more widely encompassing term of the public. And that is the public of Maryland. OPC presented the testimony of Doug Smith of the firm of Daymark Energy Advisors, as you heard under Transource's cross-examination of Mr. Smith. He readily acknowledged that PJM followed its rules approved by the FERC and that he did not design alternative lines to those proposed by Transource. What Mr. Smith did do, however, was to marshal the data provided by PJM and provided by Transource and provide an alternative way of interpreting it. For example, Mr. Ali testified that the primary goal of the Transource line was to reduce congestion in the AP South reactive interface, which is one of the most historically congested flow gates in PJM. However, when Mr. Smith, in his direct testimony, demonstrated that PJM's own data no longer supported such a project for that purpose, Mr. Horga subsequently testified that the Commission now needed to look at multiple constraints because in PJM's operation, PJM typically does not experience congestion on the AP South AEP DOM, Conestone Peach Bottom and Greyston Safe Harbor. At the same time, when one of these areas is constrained, the others typically would not be, but all areas are persistently constrained. In response, Mr. Smith, in his surrebuttal, created a pictorial graph of the congestion on these four interfaces from 2012 through 2018, which is the only evidence submitted by Transource and PJM, meaning it's only those years that data is before you in the record. And the Commission by now knows well what that pictorial graph states or makes clear. It makes clear that congestion on both the AP South and AEP DOM peaked in 2014, just around the time that PJM was creating its proposal, its RFP, and had done the studies, and since then it has dramatically decreased. Further, the the graph shows that while in 2014 congestion cost on the AP South interface peaked at about $475 million, in 2018 it was only about $20 million, a dramatic drop of about 96%. While congestion cost on the AEP DOM have recently increased to about $225 million, this is still only 53% of the congestion cost in 2014. Further, as Mr. Horga, Mr. Hurling, and Mr. Ali all testifies, there is no year, no point in time during PJM's 15-year forecast when Maryland ratepayers will know when this project has paid off or not. They will never know it, nor will anyone else. So, if a Maryland ratepayer in year 6 or 7 goes to PJM or Transource and say, is it making money? Are we now benefiting? Other than the forecast, what is the actual? The testimony before you is that no one can tell. As a second example, in his figure 4 in his direct testimony, Mr. Smith showed that from 2015 through 2018, PJM's forecast of congestions, their forecast for congestions versus the actual data that is in the record, rose, their forecast rose from 85 million to 100 million. It turned out, however, that the actual cost decreased from 56 million to 21 million. So there is a variance of about 80% already in the record of what PJM forecasted and what the actual data showed. If Project 9A receives all needed approvals, including the Maryland CPCN, Maryland ratepayers will pay their FERC-approved share of the cost of the entirety of the IEC project, not just the cost of Project 9A. As Mr. Smith testified, however, those costs have gone up by already have gone up by $32 million since the first evaluation in 2016, from approximately $340 million to the latest estimate of $372 million. Mr. Smith, in his testimony, also noted that the PJM independent monitor, which itself was created by FERC specifically to monitor PJM and the markets that PJM controls or directs, that the benefit cost analysis should also account for the fact that the transmission project costs are not subject to cost caps and may exceed the estimated cost by a wide margin. When actual costs exceed estimated costs, the cost-benefit analysis is effectively meaningless. And low estimated costs may result in inappropriately favoring transmission projects over market generation projects. The risk of cost increases for transmission projects should be incorporated in the cost-benefit analysis, which means that they're not. What is certain, and as far as reality can go, is indisputable, is that at least in this point in time, congestion costs for the PJM grid, and the word used by, I believe, Mr. Ali as well as other witnesses, the costs are volatile. And it is a challenge to accurately forecast for even a year ahead, much less 15 years. For these and other reasons, Mr. Smith concluded, and this is one of the top essential points of his testimony, the risk to Maryland ratepayers was too high for Maryland ratepayers to support the proposed IEC transmission project, which includes the Project 9A, which is before the Commission. Using estimated allocation factors, and allocation factors end up being very important in the entirety of this project. Mr. Smith calculated an approximation of the cost that will be allocated to Maryland ratepayers and the portion of the benefits from each evaluation to Maryland ratepayers. When that is done, the level of risk that the project would place on Maryland ratepayers becomes clear, as 2 of the 5 total evaluations led to a benefit cost ratio below 1, which means that in these scenarios, Maryland ratepayers as a whole are worse off economically with Project 9A in service than without. Just a few closing remarks. One, that it is there's been much testimony before the commission about the cost of the project and the cost-benefit ratio. As was discussed in Mr. Hurling's testimony with the Independent Market Monitor report of 2018, the Independent Market Monitor said that congestion is neither good nor bad in itself. And what he meant is that congestion is bad because it raises the cost of power to certain zones. But congestion can be good in the sense that when prices are high, it incents generation and can incent the generation that Maryland, by its statutes, wants to encourage. And so you have the sort of perverse effect of if and when this project works, and if congestion is significantly decreased, the correlating cost of power will decrease. But then there will be far less incentive for generators to come in. And Mr. Smith says clearly is that if the market is already responding to this based on the queue in PJM. And what he says is that the market can provide solutions that PJM can't, because it's also worth remembering that PJM cannot order a generator to build anything. The only thing that PJM can do, the only remedy that it's allowed to do, is to build more transmission lines. They can't coordinate with generators, transmission owners, and, well, I'll just leave it at that. They can't coordinate that. There's no holistic project to that, and that you need the market forces to incent that generation because PJM can't. It's been finally noted, and want to address the questions of many of the commissioners based on Professor Tierney's as well as other things. Should the commission in its decision consider the entirety of PJM? What I will comment on is that, first of all, the commission does consider the entirety of PJM because it has in the past, at least, in the recent past, given great deference to reliability projects that have gone through and been approved by the board of PJM based on a recommendation of the RTEP. Significant deference. And so that itself is consideration of the grid as a whole. This, though, as has been noted many times, is a market efficiency project. It is not the grid. There's not going to be a brownout or a blackout if this project isn't built. And if you rely, and I would note also that it's been clearly testified that there will be some reliability violations if the line is built, but also it creates such reliability violations that it's $130 million extra cost for BGE and I believe Potomac Edison to build other attendant remedies, and I think it's Potomac Edison, and that has already received a tentative CPCN from the Commission. That's $130 million on top of it, which makes the cost $372 million. And last point, if one was to consider, there's talk about winners and losers. And the winners and losers are in zones. Maryland ratepayers in the zones of BGE and PEPCO, if this project pans out based on forecast, will be winners. And at the same time, Maryland ratepayers in the Delmarva Power and Light Zone will be losers. Their power cost will increase if this line is built. And of course, they're part of our clients, which is Maryland residential ratepayers, as well as businesses, etc. And the last point in this regard, in response to that, is that what is the evidence before the Commission on this point? The evidence before the Commission is that PJM's methodology, that has been approved by the FERC, does not consider in its cost-benefit analysis the losers. And it seems fair that if the Commission is going to consider the PJM as a whole, it should have that information before it. But because, and while there have been various graphs and charts, I'm only focusing on one thing, that PJM's methodology does not consider the losers, nor set off the losers in the entirety of PJM versus the winners. It's not in their methodology, and neither Transource nor PJM have given that other part. So it seems that if the Commission were to consider PJM as a whole entity, which, as I've noted, it has in various instances, it seems to me that the Commission should have before it the entirety of the losers and entirety of the winners and see what that sets off in the terms of the cost-benefit analysis. And what I'm saying simply is that neither Transource nor PJM, what I'm saying is PJM's methodology does not, in its cost-benefit analysis, does not consider the losers. It only considers the winners and thus gives an unfair picture of the cost-benefit analysis. Thank you, Your Honor.
Thank you, Mr. Alexander. Counsel for the Public Service Commission Staff Counsel.
Thank you, Chairman, Commissioners. This application is part of a PJM initiative to reduce congestion in Maryland and also mainly Virginia and the District of Columbia. And this has been, in the past, a long desire of the Commission to support this. Project 9A, this application is part of Project 9A, but it's only a portion of it. And this case has revealed the differences between the PJM and the state siting requirements that are part of its statute. Now, staff relies on state agencies in the review of several of the criteria in the state citing criteria of 7-207, and as a result, there was a focus on the use of existing right-of-ways and existing facilities. And it still needs to be resolved whether or not this state identified solution will resolve the congestion issue. However, it is clear that in the future, proposals from PJM must address all the state priorities in the siting of transmission lines. Now, another focus of this case has identified whether or not relieving this congestion is still a state priority, apparently. The state agencies describe congestion relief as discretionary or such that it can be deferred to get the siting exactly correct per their criteria. Staff notes that in comparison from prior years, recent commission reports regarding congestion now focus on how congestion has been declining. Staff in its testimony noted that there are winners and losers from resolving this congestion, and even the Office of People's Counsel, which represents ratepayers, is not as focused on relieving the congestion as perhaps an overall review of all ratepayers might suggest that they might want to be. Now, staff's testimony has recommended denial of the application because of questions regarding the uncertainties in resolving the need for the project and the balancing of the different siting criteria. There are other issues that are going to have to be resolved in the Commission's order on this project. That's the effect of statutory changes in the land use criteria. Recent statutory changes show a preference for any local and state land use designations, and that's going to include now whether or not agricultural easements trump all other criteria, or whether or not they are considered similar to zoning criteria or other other state preferences in land use. An overall staff's analysis recommends that the Commission note that congestion relief is important and should be pursued, but whether this project as submitted could be approved is questionable due to uncertainties in the overall need for the project as identified through testimony regarding energy efficiency and renewable energy, and also whether or not the siting criteria has been adequately addressed. Therefore, staff overall recommends denial of the project as submitted. Thank you.
Thank you, Mr. Dean. Counsel for the applicant.
Thank you, Mr. Chairman. Thank you, Commissioners, for allowing Transource this opportunity to submit the application. You all have been very attentive to all the witnesses and obviously have read all the testimony and done all the reviewed all the analysis in this case, and for that we appreciate it. One thing I would like to address early on, I know that there was a concern about the interactions that Transource has had with the state agencies in preparation of this application. I can assure you on behalf of Transource that they have worked very closely with PPRP. I think that was confirmed by Director Kelly the other day, and have been working very closely with the landowners who are affected by this. Regarding the West Line, to date they've been able to procure 65% of the right-of-way easements and have been doing that through constant education and work with those landowners. We have also, quite frankly, respected the landowners who have requested that we communicate with them through counsel. So we know that it's very important for the commission that the companies that appear before you, the companies that would be providing a public service, are doing it in a way that is cooperative with state policy and state policymakers. And in addition to the letters and the information that you all have received today that have expressed concerns about this project, we would also ask that you take into consideration the letters of support that have come in as well, from not only from the Chamber of Commerce and other commercial interests, business interests, and residential interests, but from the public that would benefit from this project. We realize, quite frankly, not only from the testimony that you've heard from the landowners, but from a review of the application and review of all the testimony that's been submitted, that this is a very difficult decision for the commission. It is unique in that we have landowners that have come before you and presented their concerns. That's normally not a typical PSE proceeding where you have members of the public that are taking an active interest in a proceeding. So we know that this is a difficult decision. You have to balance a number of considerations, including the impact on Maryland's customers, the potential upside benefits that they'll receive from this project, both in terms of congestion relief, which has plagued this region for decades, really, and as a result of the reliability issues that have emerged as a result of this as well. It's been suggested that this is a case of first impression for the commission. And while this is perhaps the first market efficiency case that's been presented before you all have cited hundreds of miles of transmission over the years. And the Maryland legislature has done a very good job, as well as the commission, in adopting regulations that have helped guide the commission through this siting decision. And when we present our brief to you, we will go through the analysis not only of 7207 and the requirements there, and demonstrate how we have successfully met that burden, but we'll also address the other statutory and regulatory requirements. There are a few overarching observations that we would like to make for you. First, we'd like to dispel what has been implied or suggested in this case, that there is an inherent conflict between the FERC process, the PJM process that develops transmission solutions, and the process that we were here before you all on the siting requirements. We think that those processes should and are in concert with one another. Maryland has benefited from participating in a regional wholesale market. We have done that since 1999, and that has inured to the benefit of our residential and ratepayers. We've also benefited from having a regional transmission organization that not only ensures the safety and reliability of our transmission grid, but also does an admirable job in planning to ensure safety and reliability, as well as the efficient operation of that market. That does not suggest, however, that Transource doesn't recognize that there is a critical piece that the state plays in ensuring when a transmission application or a transmission project is identified, it must meet state siting requirements and the burdens that are placed on us through the Commission's laws and regulations. We acknowledge that is our burden, and we must satisfy the Commission not only that PJM has done an admirable job of identifying the project, but that we have met our burden of not only of persuasion, of establishing to your benefit and to your satisfaction that we've met the state's siting policies and the state's policy and the requirements that are set forth in the PUC article. The second point, so we don't think that those are necessarily in conflict with one another. We think that they actually fit hand in glove with one another. So in terms of your review of this application, we don't think that you have to find that there's necessarily tension between what PJM is doing and the role that you all are playing here today. The second point is we think that you all have gotten sort of a close view, an observation of the robust process that PJM actually goes through in identifying projects. That's probably unlike many of the proceedings that have come before you before. Not only you've been able to look at the initial analysis that PJM does to identify a project, but the reanalysis and the constant reevaluation that PJM undertakes in ensuring that projects that are presented not only to its board, but to you all for approval, meet the high standards and requirements that are placed upon them. In this instance, we had a 2-year review process that PJM undertook, not only in identifying the areas of congestion that were impacting this region, but then they opened that window. They undertook 23,000 hours of analysis of the 41 projects that were presented before it. There were the projects were presented by 19 different transmission owners. Many of them are folks that you are very well aware of, including First Energy and BG&E, all submitted proposals into this project, into this open window. Many of those projects, as are outlined by Mr. Horger's testimony, include not only greenfield projects, but many of them were upgrades to existing infrastructure. And PJM undertook an analysis of all 41 of those over a 2-year period and concluded that that the proposal that was submitted by Transource was the most robust. No party has presented to the Commission any evidence, quite frankly, that the PJM process is somehow inherently flawed, or that they did not successfully execute that in accordance with its FERC tariff or Schedule 6. And we would like you to take that into consideration. The other point that probably goes unmissed or goes missed in this whole process is that this wasn't some sort of a back-of-the-room analysis. The PJM process is a very open, transparent, and stakeholder-driven process. It includes members of not only who represent load, but consumer interests participate in the TAC, they participate in the RTEP, and they are all along the way. Before a project actually gets to the PJM board, all the assumptions that go into the calculations, whether it's on demand or load or all the forecasting, that modeling is a part of a very open process before PJM. As you heard from Mr. Hurling, the modeling, and Mr. Horger, actually takes into consideration state policy on demand response, on projected and forecasted growth, and on generation. All of that is very open and very transparent. And we wouldn't want to leave you all with the impression that this is somehow, done in behind closed doors, but without a full vetting analysis. I don't know if that point was sufficiently presented to you, but it is certainly in the record of the case. The third point is the idea that market efficiency projects are inherently discretionary, has been suggested. PJM properly opened the window to examine potential solutions to this congestion problem back in 2014. They did it in compliance with their tariff. They did it in compliance with federal law that directs RTOs to analyze market efficiency to make sure that the regional transmission system is operating in the most market efficient way. It's certainly a concern for this commission, because when you all are looking at your SOS bidding process, you see the impacts of congestion. It's not really something Transource needs to tell you about. This is something you see. It's reported, as Mr. Dean indicated, in your 10-year reports, that concerns over the persistent chronic congestion in this region is well documented, And PJM is, quite frankly, they are legally bound under their operating agreement to seek solutions for this. The idea that it is somehow discretionary or should not be taken seriously, we would reject. And it's something that you all know well, not only from your experience on this commission, but in setting rates for SOS. You see the real impact that this has on Maryland customers. When PJM, actually on the last point on there, I would reject the idea that this is somehow insignificant. I know you all have been presented with some analysis about the dollar amount that this impacts on customers. When you look at from 2012 to 2018, the impact on this region, including Maryland, has been about $1.2 billion. Those are real dollars that are impacting customers. And it's something that should weigh, that you should weigh heavily in your consideration in balancing here. The testimony that you heard was when PJM opened its window in 2014. Mr. Ali and his team did, in fact, look at existing infrastructure as a potential way to solve this issue. They looked at the PPL line. They looked at the BG&E line. They did that analysis. When you are considering your Section 7209 review, we think that's something that you should take into consideration. You now actually have testimony that in the process of developing a solution, Transource, in fact, looked at that, and contrary to what has been suggested by PPRP, when they analyzed those lines, you heard from Mr. Ali that it would not have produced a result that would have passed the FERC's 1.25 cost to benefit or benefit to cost ratio. There was, at that time, no prudent reason for them to propose a solution to this problem that would not have passed. What they did do, however, and when you think about it as well, you think about these existing lines, both PPL and BG&E were participants in this 2014 auction. They didn't propose a solution along these lines. So we can only assume that their analysis was consistent with what Transource saw, that at the time, those lines would not have produced a result that would have passed that threshold. Mr. Ali and his team did go back and look at what was later determined to be a fairly unique and innovative solution to this problem by developing two lines, one on the west and one on the east. And what this would do, and what the testimony shows, is it not only solves the congestion that we're seeing and have seen in the AP South interface and related constraints there, but it does it by having the east line that assures that we're just not pushing this problem to another state or another region. They work in concert with one another. And that was what was determined to be the most robust and unique and innovative solution to this problem. And PJM didn't just stop. Once they awarded this project, they didn't stop and just say, all right, you've got it, go. Part of Schedule 6, part of the RTEP process is to constantly reevaluate these projects. That's not just Project 9A, but it's all the projects that are approved by PJM. And after each evaluation over the last 4 years, it's been determined that is Project 9A is the most robust solution to addressing this problem. PJM, I would reject the idea that there's a suggestion that this congestion problem is going away. We've heard from Mr. Horger, we heard from Mr. Hurling that they have projected this congestion problem to persist and actually increase in the future. Now, after Transource was awarded this project, they entered into a designated entity agreement. And that is attached to our application as something that's in the record that you all can review. And that entity agreement required Transource not only to seek the permitting necessary to construct their project, but it had a very specific specifications and electrical solution that was required. There's been a suggestion that to site this line, you simply need to go from point A to point B. And while there is truth in that we need to get on the east line, that we need to go from Furnace Run down to the Conestone substation, they had to do it in a way that would be consistent with the terms of the designated entity agreement and the electrical solution that had been approved and designed as a result of the open window. So when Mr. Baker and his team were looking at proposed routes, they had to do it in a way that would produce the electrical solution that is required under the DEA, or the designated entity agreement. On the west line, there was an existing, and there is existing transmission lines that they were able to propose to parallel. On the east side, the PPL BG&E line unfortunately could not be paralleled because of existing homes and other restrictions on that side. So they had to find a route that would be the least impactful. What they couldn't do, however, and I would reject, that they could not use the existing line because it did not have the capacity that was necessary in order to meet the specifications and requirements of the DEA. The last few points that I'd like to make, I know that part of our briefing we will focus on Section 207. We understand that that is a requirement, I'm sorry, Section 209, that is a requirement that the Commission needs to examine. It is a statute that was passed in 1976, a little bit before we elected to restructure our industry. It was more part of the integrated resource planning that the Commission did and the state did back in the 70s. However, it's still on the books and it's still a requirement, and we know that this Commission needs to satisfy it. And while we'll lay out a little bit more of how we suggest that the evidence allows you to do that in our brief, there are 3 points I'd like to make on that. First, you have Mr. Ali's sworn testimony that they did, in fact, examine the existing infrastructure. You also have, in the record, from Mr. Horger's testimony, a discussion of the 41 proposals that were presented to PJM in the open window. Those 41 projects consisted of both greenfield projects as well as upgrades to existing infrastructure. So those are things that this Commission can take into consideration in its examination. You can also rely on the evidence that Project 9A itself consists of both greenfield and existing infrastructure, both the BG&E infrastructure from Conestone down to Northwest, as well as the PE infrastructure that goes from Ringgold to Catoctin, thank you, are all part of the record in this case and would consist, those things would all go towards your examination under 7209. The third and probably most critical is the fact that in this record, really appreciate the work that PPRP did in this. We've examined 7 conceptual alternatives. All of them are using existing infrastructure. They do not, many of them did not pass the reliability screens or the cost of benefit analysis, but they were analyzed within this case. And in fulfilling your obligations under 7209, you can rely on that evidence as well. I would like to talk to the Commission about conceptual alternative 3A. And again, we did work over the last several months with PPRP and their outside consultants in looking at these alternatives. PJM ran the analysis on the initial 4. We worked, both Transource and PJM worked with PPRP on modifying some of them in order to see if we could get them to pass PJM's reliability screens. We did that. One of them does, in fact, pass both the reliability screens and it passes the FERC benefit to cost ratio. Albeit does it at a lower level than Project 9A. It is more expensive. It provides less congestion relief, but it is a viable alternative. And what I'm prepared to tell this commission is if there is a desire on this commission's part, realizing that there is a less congestion benefits from 3A, but if working with our key stakeholders in Maryland as well as in the state of Pennsylvania, because this would have to be something that's done in concert with both Maryland stakeholders as well as the Pennsylvania stakeholders, as well as, quite frankly, the incumbent transmission providers. But if there is a desire on this commission's part to explore 3A, I can tell you that Transource is willing to work with PJM to see if that it would be a viable alternative for the commission. It is something that would have to be done in concert, obviously, with the IEC West line. But again, you will have many issues that you must consider and weigh in a CPCN. And if that's something that the commission wishes to explore, Transource is willing to do that. My final remarks, and I'm sorry, I'm probably going over to the 10-minute period, but we realize that this is a difficult case, and we were out in Harford County with you all when you heard many of the interested landowners and stakeholders out there express their concern. But what we would hope you would not do is to kick the can down the road. You have an opportunity, Maryland has an opportunity to really take on this issue. Not only the issue of congestion, which you all have seen in the rate setting process, but also to take on an emerging reliability issue that you're going to have to deal with eventually. If you reject this line, PJM is still duty-bound to address the congestion issues. There will be other projects that will be presented to you. And we know that they are appropriately duty-bound to address this 500 kV line. We believe that you have a record in front of you now that is very robust and would give you the opportunity to take this issue on now and not address it later. Obviously, we advocate for the solution that PJM has identified and awarded. But again, understanding the balancing of interests that you all must undertake would work with our stakeholders in this commission, the commission in Pennsylvania, to find a solution that addresses both of these congestion problems and the reliability problems now. Thank you.
Thank you, Mr. Coran. I wish to thank the parties for their professionalism and their efficiency over the past 6 days of our evidentiary hearings. I'd also like to thank our court reporter, Linda, for her hard efforts here, and I wanted to get that on the record as well. Now it's off to the briefing schedule as was discussed yesterday. Briefs are due now in 49 days from today, and we'll then receive reply briefs after that, subject to further order of this commission. This evidentiary hearing is now adjourned.